Yes.
My Lords, before lunch, we were just dealing with the 7th of March 2000 and the application, and I'm afraid, in fact, I worked out what's happened. On my outline chronology, I inadvertently deleted the 7th of March date at some ungodly hour this morning and didn't put it in. So if you wouldn't mind on the chronology just writing in the 7th of March, as you know, the first application to set aside is page 121.
Sorry, where do you want us to write this in?
This is between the 1st of March 2000 and the 11th of January 2001. So 7th of March 2000. And the application to set aside is 121. And the supporting affidavit is 122 to 125. And I think I had, just before the short adjournment, shown you the material parts of that affidavit. Can I then pick it up? The affidavit of the 11th of January I had also shown you before the short adjournment, albeit out of order. And then on the 14th of February, there was this further motion, which we again looked at, just page 139, you can see that. I've never yet been entirely able to work out why it was necessary to file a further application, but I'm not sure anything turns on that. And that was supported by an affidavit of the appellant again, and that's at page 140 to 145. And you can see the provisions of that affidavit, and I hope I've taken you to those material parts again. That brings us on then to the 7th of November 2000 to the 2nd of August 2001, which were the hearings before Her Honour Mangatau, which is page 186 of the volume. And you can see the dates at the top of page 186. You can see trial, the whole series of dates from that start on the 7th of November, various dates leading all the way to the 2nd of August 2001. In the interim, in the High Court, on the 15th of March 2001, Garth Little swore an affidavit, and that's page 149 to 151. And again, I think I'd shown you the material parts of that before the short adjournment. And then there was the affidavit of Miss Hines. Can I just show you that at page 145? It appears, although no one's been able to confirm this directly, that by this stage her application to join has been dismissed or in some respects dealt with. And she's swearing this to support Keith O'Connor. And she says in paragraph 2 that she's the person in possession. And in paragraph 3 she deals with her agreement in 88. And that based on that agreement she paid the first plaintiff a deposit of $20,000. And that she subsequently entered into possession and began to pay rent to the first plaintiff, and that would do so until Paul Piccott was able to obtain certificate of title. And then at paragraph 6 at the bottom, that before this could be done, the registered proprietor of the property, Keith O'Connor, who had been residing outside of Jamaica, returned to Jamaica claiming possession. And that I believe the matter was tried in the Supreme Court, and that's the closest we've got to it being a trial. 22nd of May 1990, judgment in his favour. Advise and believe rendered the sale of the property void, whatever that might mean. And that after Keith O'Connor obtained the order, she received a letter from Mr. Little saying, pay me, as it were. And then she did, paid the full purchase price and lived there since. And she says, paragraph 13 on page 147, that the relevant subdivision approval has now been granted. The plaintiffs, and then she refers to the suit at Halfway Tree Residence Magistrates Court.
That's approval by the registry, is it the land registry, is it?
Yes, so the approval, the title can be subdivided. And she is the one who exhibits the submissions from council. Plaintiffs knew effectively that the property didn't belong to O'Connor because it was revealed to them. And then she says that at paragraph 18, the plaintiffs have obtained a default judgment which states that Keith O'Connor should deliver up to the plaintiffs the relevant unencumbered certificate of title. I'm advised and believe that it was obtained without full disclosure and by misrepresentation. So that's what she says on that date. The next date is the 22nd of March 2001, and that's page 152, where you just get an order that the motion to set aside the order of Mr. Justice Ellis is dismissed because it's misconceived, because a judge of coordinate jurisdiction can't set aside a judgment on motion, decided on the merits, costs to the plaintiff. No formal order, so as far as I've been able to discern, in relation to Miss Hines's application, so at least implicitly rejected. And at page 161, this is the affidavit of Pamela Gale, which was sworn in support of procedural matters in the Court of Appeal, which, so happily your lordships don't need to worry about that, but at least you get some flavour of what she says happened. Paragraph 5, I attended on the 22nd of March when the motion to set aside the default judgment was scheduled to be heard. When the matter came on for hearing, the plaintiffs informed the court that the order made by Miss Justice Ellis had been granted after the matter had been heard on the merits. I indicated to the court this was inaccurate. Further attempts to elaborate were cut short. Met with the response the motion was misconceived. And then she goes back to what she's been told by Garth Little about what happened beforehand. And she also affirms at paragraph 13 that the pleadings prior to the order of Mr. Justice Ellis disclosed that the plaintiffs had not paid any money, either as a deposit or purchase price, to the defendant herein. Then on the same day is an affidavit of the appellant, and can I take you to page 153? And he deals at paragraphs 4 and 5 and 6 with the application before Mr. Justice Cook, and I don't think there's anything materially different in that respect. And he then sets out at pages 154 to 155 a summary of the history as he sees it, and I think your lordships have had most of the material part, so I hope I'll be forgiven for not detaining you with that. And at paragraphs 20 and 21, the reasons why he didn't attend. And again, I think we looked at those shortly before the short adjournment. That he knew he'd never signed a document, and which was that he'd had the order.
Well, he said exactly the same in the previous document.
Absolutely, my lord. Nothing's changed. Continuing then through the chronology, on the 7th of August 2001 is when we get judgment from Her Honour Mangatal, and that's page 186. And the background is set out, not all of it, but quite a lot of it. There is that curious feature which my Lord Sir Jonathan Parker referred to about the reference to a consent order. And then at page 193, the gist of the decision is set out. All told, weighing all the evidence and having regard to several court orders, I cannot say that I'm satisfied on the balance of probabilities that the plaintiffs are entitled to possession. This is so because the agreement wasn't put in evidence before me. No other documentary evidence was put in. Defendants produced an agreement between herself and Miss O'Connor. The defendant obviously being Maisie Hine.
Now this is the third, these proceedings on which this judgment was given, the third set of proceedings by the first respondent, is that right?
Yes, my lord.
For rent, in effect.
Well, rent and possession.
And possession, yes.
Yes, my lord, yeah.
And do we know why there were three sets of proceedings?
No. No. The only speculation, and it is entire speculation, is that there, inevitably, if you're issuing proceedings for arrears, once you start, then for any further arrears, then you need to start a new set of proceedings. But that's the only sensible explanation that I was able to come up with.
Oh, I see,
I'm afraid that's speculation, my lord.
And do we know what happened to the other two sets of proceedings?
Well, we know that the proceedings in front of Her Honour Miss Francis were dismissed. That was 95.
I thought there were two other intermediate.
Oh, the intermediate ones. No,
Stayed, was it right?
not as far as I know. In relation to
There are two that were stayed. See, the 15th of July of the 1999.
yes, some were stayed. Can I take you to 172 at the bottom? Thank you very much. Where I've been given some help. This is from Pamela Gale's affidavit, and she says that paragraph 9, the 2000 proceedings were subsequently adjourned sine die by Miss Francis. So it looks like those were adjourned, and everyone fought on Her Honour Miss Mangletail's judgment. But there are no orders to that effect that I've been able to locate. And that was, so continuing on, page 194, the judgment continues. A sort of rhetorical question is asked about in the middle paragraph. Could the argument not be made by Miss Hines? Mr. Piccott should now complete the sale to her and get her money back from Mr. O'Connor. That might not affect the question of payment of rents. Even if I'm wrong, he then said the claim was exorbitant. She then said the claim was exorbitant. Perhaps the last comment on page 195 might commend itself to your lordships, but it's not something that takes the legal issues any further forward. Can I then give you the next date, which is the 12th to the 13th?
It's just over 25 years since the agreement, which specific performance is now been decreed.
Yes, my lord, yes. And then the next date is the appellant's appeal in the Court of Appeal, which was page 333 of the next volume, and then you have the judgment of the Court of Appeal dismissing the appeal. And I will turn to that when I deal with submissions. But I hope that is a proper summary of the material from the record and also from my learned friend's affidavits. There are two further dates there which aren't evidenced on the record, and perhaps the easiest thing to say about that is that there are still further proceedings ongoing.
The November 2006 item, what is that?
That was when Mr. Piccott obtained a warrant for possession against Miss Hines, which appears to have been done.
I see. Then that's what was decided upon, was it?
And then that was set aside. Yes.
We don't have the judgment of his.
No.
Okay.
Just know from documents that's happened, but nothing that takes your lordship's analysis any further forward. Can I therefore make a number of submissions from the materials that are now before you? The first is this. It doesn't appear to be contended on behalf of the plaintiff's material, the appellant's material, that he ever gave actual authority by O'Connor to sell these flats. All that is contended on his further affidavit is that he signed draft agreements which in fact were never then sold. There was, as you can see from the affidavit evidence, an apparent proposal that he should sell the whole flats, i.e. the whole property, to Silvera and Tomlinson, but that doesn't appear to be the basis on which any of these claims can be bought, and indeed doesn't appear to have been what Silvera claimed to have completed on. The second point is this. It does appear that at some stage everything went wrong because there were all sorts of difficulties with subdivision in the sense of conveyancing matters that might hold up any sale, and that in that interim period various agreements were made that people should enter the property and pay rent. And that it was during that interim period that the proceedings before Mr. Justice Harrison were bought and completed. And everyone understood, brackets perhaps misunderstood, the effect to be that everything that had gone before was void. And certainly, so far as Miss Hines was concerned, she then subsequently paid rent, as you know, directly to the the appellant, and entered into a contract for sale with him. And Mr. Justice Harrison's orders, for what they are worth, were to the effect that the purported sales were no longer binding. I mean, that is the effect of the use of the words void. And that appears to have been the misunderstanding or understanding that everyone had at the time. For all those reasons, we do respectfully submit that there is plainly a good defence that the appellant can bring on the merits of the claim for specific performance that is made by the respondents. He doesn't have the property to sell. And indeed, I mean, if the letter of the 5th of April 1991 is accurate, all this has been an attempt to enable Mr. Piccott to take advantage of subsequent prices that have occurred. Now, whether that's right, that was the allegation that Miss Hines's lawyers were then putting to Mr. Piccott. All the equities in this case, wherever they may lie, can only be satisfied by giving Miss Hines possession and title to the property, which means that specific performance was plainly misconceived at the time that the judgment in default was signed.
Would you say that was misconceived even if, as I suspect is going to be said against you, that your client had in fact agreed to sell this property to the respondents, but then purported to sell it to Miss Hines?
Yes, because if one's looking at the equities, as far as Mr. Piccott was concerned, he'd sold to Miss Hines, not had any money, true, but he'd sold to Miss Hines, allowed her into possession, and she had purported to pay some deposit. So the equities can only ever be satisfied by allowing Miss Hines to stay in possession, she having, on any view, paid the monies. The division of the proceeds of sale, reasonable people can argue about, but it was never going to be resolved by a default judgment for specific performance. In very much the same way, it was never going to be resolved.
So if I'm understanding you correctly, if one assumes that your client was wrong, I'm using that word in a very broad sense.
Yes, yeah.
In other words, he's sold this to the respondents, and I'm using sold in a non-legal sense, and then proceeded to sell it again to Miss Hines. Would you say then that specific performance in favour of the respondent can't work? It would have to be damages or...
Yes.
Well, have to be damages.
It would be damages for breach of the contract of sale, and his damages would be, look, I was going to get $240,000. In fact, I didn't get that.
And again, putting it in general terms, you would say that because there must be, you would say, a very good case for Maisie Hines that she's got a perfectly good title for which she's paid.
Indeed, my lord. I mean,
and therefore there can't be any question of specific.
No, inevitable in any case involving equity, everyone always pretends to be the innocent purchasers, etc. But if there is any party that is less blameless or less to be blamed than anyone, it does appear to be Miss Hines. I mean, and I say that obviously representing Mr. O'Connor. And
it's rather a pity she isn't here, isn't it?
She did try, I suppose, is all that can fairly be said on her behalf in absence. But, my lord, in our submission, that also does pick up merits between the appellant and respondents, because when the issue as to whether or not it was a sale in a loose use of the word rather than the legal sense, or whether in fact it was all done without Mr. O'Connor's say-so or agreement, it does appear that he has managed to persuade the judges that that's what occurred. First of all, Mr. Justice Harrison, which of course explains, but certainly doesn't excuse why he then took the ridiculous approach he did, which was not to defend the proceedings. And more relevantly, when the issue has been engaged in litigation between Miss Hines and the respondents.
Supposing the order presently in force, as it were, operates, what is going to happen on the ground? In fact, it hasn't been executed in any way, has
No,
it?
there have been stays that have been obtained.
But what would happen?
Well, the order provided in standard form, as your lordship sees, for effectively the conveyance to be done by the defaulting party, i.e. us. We've not done it, and then what you do is you write to the registrar, and the registrar conveys title. And a registrar conveying title conveys title, and then you'll get into all sorts of arguments about whether or not, in relation to the land system that exists in Jamaica, Miss Hines has any protection at all. And they're very real concerns that if you have an order for sale from the court, that then Miss Hines's equities, or whatever they may be, are simply overridden. Because if you go back to page, if one looks at the record and sees what order was made, that was the effect of the order that was made. Page 7 of the record. At paragraph 3, that if the defendant fails to abide by the terms, the registrar be empowered to execute a valid transfer to the plaintiffs. The registrar be empowered to endorse this transfer upon the duplicate certificate of title.
But how could the court have directed that, given the transfer to Miss Hines?
Well, they didn't know about the transfer to Miss Hines. This was between the...
Oh, this was originally?
Yes.
Yeah, but this is not the...
This is the 98 order, which was Miss Hines...
and how does that compare with the Court of Appeal order, or the judge's order? Where's that?
Sorry, in the Court of Appeal, I think they effectively dismissed the appeal. If one looks at the judgment...
I mean, this order stands, doesn't it?
Yes. This order stands, yes. Sorry,
Yes, I mean, they just dismissed the appeal. If one looks at page 349, you just see appeal dismissed, costs to the respondents.
I mean, this first of all,
Yeah.
this order doesn't identify the agreement in question. It talks about the terms, presumably that's the terms of whatever agreement it is that this order refers to, is it?
My Lord, there...
We don't know.
No, I mean, in terms of an order that one was ever seeking to put before a registrar, you can imagine the registrar of the court having difficulties.
I mean, there might be some dispute about how much is payable, assuming one can identify the agreement.
There plainly is. You can see that even if you accept Silvera's figures, he says 80,500 outstanding. And then you can see, I think the Picos contended they'd already paid 49,000 or 40,000. I forget the figures. I showed it to your lordship.
It seems to me that it's questionable whether this is workable at all.
Well, we would respectfully make that submission.
The PC8 and PC9 is the affidavit in support of notice of motion.
Yes. Yes, and you see the figure of 42,000 at paragraph 11 that they refer to.
Yes. Where do they say that the agreement is made with the defendant?
Paragraph 2 is we entered into an agreement with Tomlinson and Silvera.
Yes.
No,
who are not defendants.
no, that is a point we have taken, my Lord. I mean, the closest, to be fair to the Picos, the closest they get to dealing with that is paragraph 2 of their statement of claim in paragraph page 3.
But you'd expect it to be said somewhere that Tomlinson and Silvera were acting as agents for your client.
Indeed. And
Now, they do.
Do they say that?
in paragraph 2 of the statement of claim.
Of the statement of claim,
Yes.
which is again where?
Page 3, my lord.
They don't say it in the affidavit, that looks.
But they don't say it in the affidavit.
And you don't have to have a statement of truth, perhaps, in the.
No, and, well, you've seen the points that were made about misrepresentation in relation to Mr. Justice Harrison's judgment, and also the failure to disclose the fact, which was known to them by now because it had happened in '95 and they'd asked to buy the property themselves, that Miss Hines had bought it. And, my lords, perhaps in relation to the merits submissions that one draws from these propositions, I could pray and aid the fact that the respondents themselves had asked to purchase the property from Mr. O'Connor, according to his evidence. I mean, how far that takes the matter, but it at least explains why Miss Hines did, and also supports what might be considered to be a common misunderstanding about what Mr. Justice Harrison had done. Can I, against that background, then turn very briefly to the further legal submissions in relation to Section 258 and the Civil Procedure Rules?
Well, as I understand, you've got two points as far as the Court of Appeal is concerned. Firstly, that, well, it may not be firstly, but one of them is that if you, any analysis, however imperfect, demonstrates that it is likely, to put it at its lowest, that an order for specific performance will cause even more chaos than has existed to date. I'm trying to put it as neutrally as possible, because you have Miss Hines' position to be taken into account, and she's not a party to this judgment.
Indeed, my lord.
And then your second point goes on whether the rules or the code applies, as I understand it.
Yes, and
have I got your two basic points?
those are the 2 points we take on the judgment. Perhaps also in relation to Miss Hines, I can say this, that the respondents' approach to Miss Hines is perfectly plainly evidenced by the fact they've been seeking possession consistently ever since they got the default judgment. What they will attempt to do with it if the order is upheld. So far as the second...
On one of the affidavits, they appear to have launched no less than 7 proceedings for rent and possession.
Yes.
Some of which they've given up, some of which they've lost,
yes,
and others appear to have disappeared into the ether.
Yes. Along with a number of files, which is no criticism of anyone, but some of the court files, because trying to find some of these judgments for you have proved very difficult.
What do you say about the code and the...
Can I address that very briefly, which is this, that the material part of the transitional provisions relating to the civil procedure rules were identical to the material parts of the transitional proceedings in England and Wales. Perhaps I can take it by reference to my case, which may assist in shortening the submissions. And if you... Can I pick it up at paragraph 29? Where you can see that 1st of January 2003, which is, as your lordships know, after the dismissal by Mr. Justice Cook and before the Court of Appeal.
So before 2003, what was the...
The Civil Procedure Code. You were handed, out of turn, as it were, a document which should have got into...
Yes, I think we've got it.
Yes, and if you turn to paragraph 258 of this, you can see in terms...
This says that it's got brackets in the front, 1st of June 1889.
Oh, it started then.
And then it says reproduced 1st edition, November 1988.
Well, certainly Easy Law's contribution to it. But at 258, it's the penultimate page. You can see any judgment by default may be set aside upon such terms as to costs or otherwise as such court or judge thinks fit. So it was very much in the same broad terms as the English practice.
What, pre-CPR?
Yes. And then, if one follows through on paragraph 29, the judgment of Mr Justice Cook was the 22nd of March 2001 and governed by the Civil Procedure Code. He, in fact, as your lordships know, appears to have taken the view that it was a judgment on the merits. Then paragraph 30 sets out 258. And then paragraph 31, the civil procedure rules say at section 13.3, and that's in the bundle before you, but I hope I'll be forgiven just by picking it up from here. The court may set aside a judgment only if the defendant A, applies as soon as reasonably practicable, B, gives a good explanation for the failure to file an acknowledgement, and C, has a real prospect of successfully defending the claim. So they were, as it were, cumulative provisions. But, and this is an important but, so far as the reasoning of the Court of Appeal is concerned, the transitional provisions under the civil procedure rules are set out in 73. And can I just ask you very briefly to turn up paragraph 1 of the bundle of authorities? And if you look at the scope of this part, you can see commencement date at 73.13 is the 1st of January. Old proceedings mean any proceedings... Sorry, my lord. Commenced...
Sorry, I'm not quite speaking for myself. I haven't quite just got... Which page are we on?
425 at the bottom. It's headed,
Tab 1, is it?
Yes.
My authorities bundle seems to have mysteriously disappeared.
Oh, sorry, my lord.
It might be down here. In the,
Is it? No, I had it this morning.
Is it done now? I found mine.
I found mine too.
Well, I'll certainly find it. It's here this morning anyway.
I'm sure we can find...
If you wouldn't mind, I don't know where it's gone to. Oh, thank you very much. No, I'm okay. It's all supplied. Thank you very much. 7313.
Yes, and it's page 425 at the bottom.
Yeah.
You can see commencement date means the 1st of January 03. Old proceedings mean any proceedings commenced before the commencement date. And then new proceedings. These rules apply to all proceedings commenced on or after, so we're not in that. And these rules don't apply to any old proceedings in which a trial date has been fixed to take place, unless that date is adjourned. And then a whole series of provisions, the gist of which is that if you get a case management conference, you then get the new rules, see 426 at little 6. And if one looks at 73.5 for the transitional provisions, where the new rules don't apply, where the former rules still apply, and the court has to exercise its discretion, may take into account the principles set out in these rules, and in particular parts 1 and 25, and the material part of that is the overriding objective in part 1. And this was exactly the same problem that confronted the English courts. Can I take you to paragraph 33 of my case?
But just before you look at what the English rules were, what do you say is the effects of 73.3 in this case?
That these rules didn't apply because we're not within any of those parts. And therefore, for that reason, my lord, you're left only with 73.5. And
is this common ground?
I'm not sure my learned friend's case...
well, we can obviously ask.
At paragraph 33 of my case, if I can pick it up, the transitional provisions, like their English counterpart, didn't expressly deal with the application of the new rules to appeals. And you can see that from 73.3. They're all bits about starting a new trial. And the approach taken by the courts of England and Wales when confronted with the same issue arising out of the commencement of their rules was set out in McPhellamy. And Lord Wolford said this: the transitional provisions contained in the practice direction don't expressly deal with appeals. The general approach should be obvious. If the decision is one which this court would have interfered with before April 99, in deciding what order should be made for the future, this court will take into account in particular Part 1 of the CPR. Can I just take you to that brief extract? And it's really as good as you can get.
So what does that mean?
It means you can take account of the overriding objective, and should take account of the overriding objective, because the new rules don't expressly apply to the appeals. Can I just actually show you the passage itself, my Lord, which it's in Divider 15.
I mean, is that any different from the old rules? I mean, applying the overriding objective, which after all simply says cases have to be determined justly.
No. And
I mean, it's as if this didn't arise.
Effectively, because, and the important point is this, I mean, in Jamaica themselves, they've changed CPR 13.3, as my learned friend has already kindly pointed out in his case, because it was always capable of being an instrument of oppression, where someone didn't have what the court might consider a very good reason and act without delay. And indeed, if one looks...
Have they been changed in England, or do we still have the...
No, we didn't have 13.3. They modelled 13.3 on Canada, I think, my learned friend told me, and I've not been able to find where it comes from. I'm very happy to accept his research on that. Can I just give you the reference at Divider 15, page 792, to McPhellamy? You don't need to know anything about the case. It was a question in relation to amendments in libel actions. And Lord Wolfe's judgment, at the end of the main judgment, simply dealt at page 792 with the issue of the impact of the civil procedure rules on outstanding appeals. And he says, I give an additional judgment to draw attention to broader issues. The first of those issues is the impact of the civil procedure rules on appeals from decisions of lower courts given, as in this case, before 26th of April 99. Transitional provisions contained in the practice action do not expressly deal with appeals, same really as here, although ours is in the transitional CPR. The general approach should be obvious. In reviewing a decision made before the commencement, this court will not interfere after that date if it would have done so, if it would not have done so if the appeal had been heard prior to that date. This court only interferes with the decision of a court below if that decision was wrong. If the decision was not wrong before commencement, it doesn't become wrong for the purposes of an appeal as a result of the subsequent coming into force of the rules. However, if the decision is one which this court would have interfered to before the commencement, in deciding what order should be made, this court will take into account, in particular, Part 1 of the rules. And that's as good as it gets. And effectively, that has been applied. I mean, there are very few transitional cases now left, as your lordships will know. In fact, I'm not aware of any in England and Wales. And that effectively, everyone looked towards the overriding objective. But as my Lord Clerk indicated, that may not have actually led to many practical...
But the Court of Appeal in this case did actually, to a degree, decide that the decision below was wrong on the basis that it was a default judgment, not a judgment on the merits.
They did, my Lord. But then they went back. I mean, in our submission, the error they made was when they had regard to, if one goes to page 348 of the record, I ought perhaps to start at page 347, where the learned judge, having summarised submission, says the appellant O'Connor contends he's a good defence, but these are the circumstances in which he seeks assistance, failed to file a defence, consent had been given for him to do so out of time, failed to make any application to the court for extension of time. As to the last sentence, I've not been able to follow through where any of that had come from. Counsel represented him at the hearing, and you've seen that. The order was made pursuant thereto, states he was heard. He was entitled to be heard with regard to legal submissions. The appellant had therefore taken a deliberate decision not to defend the matter. Paragraph 21 makes no mention of impecuniosity or absence of knowledge. No doubt that Ellis was seized with jurisdiction. I'm of the view that, having regard to the circumstances, the matter was not decided on its merits, the point my Lord Lords have put to me. Although counsel for the appellant appeared, the matter could not have been decided as no defence had been filed. Mr. Justice Cook was correct in exercising his discretion to refuse to set aside and extend time. The appellant had deliberately ignored the procedural requirements, having taken a decision not to defend. He couldn't have been ignorant of the order. Thereafter, he took no steps in a timely manner to seek to set aside the order. Section 13.3 now governs the procedure for setting aside default judgments and says, and the requirements of the above-mentioned section are cumulative and in the circumstances have not been satisfied. And I infer from the judgment before that the learned judge must have been referring to applying to the court as soon as reasonably practicable and failing to give a good explanation.
It doesn't look as if the Court of Appeal was referred to the transitional provisions point.
No, my lord. As far as I can see from the submissions, I'm not sure that anyone actually referred to the new rules in the submission. Because if you look at, for example, page 329, these are the defendant appellant's written submissions. You can see reference to the Civil Procedure Code. And then at page 330, the new rules, it says, even if the application is brought under the new rules, the appellant is entitled to succeed, which is perhaps less than full.
Well, I suppose it depends what's decided in Caribbean Depot.
Indeed, my lord, I'm afraid I can't assist with that. But, I mean, picking up the point that my Lord Savile made to me at first thing this morning, in my submission, one can see that certainly influencing the judgment of the Court of Appeal is the fact that the requirements are cumulative and haven't been satisfied. They then do refer to wide powers to adopt a flexible approach. But having considered the circumstances, I see no basis in which the court should exercise its discretion. We respectfully submit this.
So you said on the basis of the Lord Wolfe's approach, assuming that to be appropriate here, then you first of all asked what would have happened.
Yes.
If you like, in England before that.
Yes.
Or possibly in Jamaica before that. And if the court if the court concluded the decision was wrong in the relevant sense, then it will interfere.
Yes.
But what order it will make will have regard to the overriding objective.
Indeed. And can I just, in relation to Jamaica, make this submission by reference to an authority? I don't propose to take you to it unless anyone would like me to. Is that Strachan and Gleaner, which is in your bundle of authorities at Divider 21, if your lordships consider that procedural messes have occurred in this case, Strachan and Gleaner in some respects mirrored it. And the question there was whether or not a judge had jurisdiction to set aside a judgment after a contested hearing on the merits of an assessment of damages in a libel action, and it was held he did. But the important point from Strachan and Gleaner for these purposes is that they effectively applied the English test to the Jamaican proceedings. And with that in mind, can I perhaps make this overarching submissions on some of the authorities? If one looks at Evans and Bartlam, and that's in Divider 10, or Van and Orford, which is in Divider 24, or the Saudi Eagle, which is Divider 5, in all those cases, either the court at first instance or the appeal court being put right had all been over-influenced by considering that some factor outside the merits was over-influential. I mean, for example, in Evans and Bartlam, everything got diverted by whether there was approbation and reprobation. In Van and Orford, everyone was diverted by whether or not the defendant had lied in his first dishonest explanation for failing to set aside. And in the Saudi Eagle, although the result didn't change, everyone was diverted by the insouciance, as it was described, of the defendant who decided that the judgment was without merits. And
I'm not, it's my fault no doubt, but I'm not at the moment entirely clear the path that the Court of Appeal took. They certainly appear to hold that Section 13.3 of CPR governs, because we can find that on page 348 to 349.
Yes, we know.
But they also appear to except that they nevertheless have a discretion.
Indeed, my lord, if you look at paragraph 32,
Yeah.
albeit one informed by the cumulative provisions set out above.
But if you go back to the pre-existing rules, the three requirements of section 13.3 of CPR would certainly be relevant factors under the old law. Would they not?
I mean, relevant factors, it's the weight that you give them, my lord. I mean, if one looks at, for example, I mean, I can take you through the authorities if you would like me to, but if you look at where people had gone wrong...
Sorry to interrupt. Yeah, no, I understand that entirely, but they are relevant factors.
Oh, no, I certainly don't seek to submit otherwise. Yeah.
And what are you saying, that the court shouldn't actually have looked at CPR? It could have taken into account these factors, but and then I'm slightly. This is where I'm unclear about the reasoning of the Court of Appeal. They shouldn't have given them the weight that they appear to have done?
Well, they must have got, in our submission, the weighing wrong to have come to the conclusion that this order could stand. Because it's a nonsensical order for all the reasons I've submitted. It's unfair to say he's done nothing about it and had no reason to come to look at this matter, because he'd been to Mr. Justice Harrison, he'd given evidence in all sorts of other proceedings.
But that really rather goes back to your I just want to wonder whether you've got 1 point or two here, because you can say, and you do say as I understand it, that the Court of Appeal got it wrong, because if you look at the situation in any depth, whatever the final rights and wrongs of it are, it's going to produce an impossible or very, very difficult situation, particularly as regards the third party in the form of Maisie Hines, which doesn't seem to be something that they have addressed their minds to.
No, my lord, but in my submission, well, I'll make this final submission on it, and whether it is a separate point or conflates with the first. Perhaps I can just try it like this. If one looks at page 348, at paragraph 33, you can see that the Court of Appeal, in the one judgment that's given, set out the circumstances. They say, at about line 6, in my opinion, Mr. Justice Cook was correct in exercising his discretion. The appellant had deliberately ignored the procedural requirements, having taken a decision not to defend the matter. And that appears to be the principal reason that they then refuse to set it aside. And in that respect, they fall into the errors that were made in Van Norford and everything else, rather than, and Evans and Bartlam, which tells you to look first at the merits rather than at the failings.
For my part, whatever the answer may be on the terms of the rules, your case, as I understand it, is that the Court of Appeal simply failed to take into account a crucial factor, namely that to allow the order of Mr. Justice Ellis to stand, whatever it be, whether it be a default judgment or a judgment on the merits, whatever it be, would produce a chaotic and unworkable situation, you say.
My lord, those are my submissions. I mean, summarised that way. I have attempted to provide other routes to the same way, but I entirely accept that as the summary of our case.
I mean, so far as their approach is concerned, they could have said section 13.3 of the CPR applies. That is a tough rule because of the words only if in the preamble. And since you simply can't establish B, that's tough, that's the end of it. And indeed, there's an English case which says something very, very close to that, as I recall. But in fact, they didn't do that, as my Lord Savile has pointed out. They then appear to have applied the overriding objective, in which case we're back where we started, really. Yes. Or something close to it. And then you have the various points you were just making.
Yes, although perhaps it then is giving inappropriate weight to certain factors and not giving appropriate weight to others.
I mean, they thought that your client made a deliberate decision not to challenge this, and that's tough. But like Mr. whatever he was called in the Saudi Eagle.
Yes. And indeed, I mean, that part of the Saudi Eagle, the Court of Appeal didn't approve of the approach taken by the judge at first instance of saying insouciance and that's it. But they came to the same result for different reasons, because there was nothing in the merits as they perceived it.
As I recall, since I was the losing counsel in the case, Mr. Justice Staunton, at first instance, said that the case had legal merits but was not meritorious.
And the Court of Appeal disagreed with him in that respect.
They certainly took a dim view, I remember.
My Lords, those are effectively our submissions on the two prongs as I put it, and still commend them to your Lordships for attacking the judgment of the Court of Appeal. And we do respectfully submit that really what is required is a hearing where everyone's there who's got an interest and the matter is sorted out, if the matter cannot then be sorted out in the interim. Those are my submissions.
Thank you very much. Mr. Lippman? Yes, Mr. Barnett.
Please, your Lordships. The judgment of Mr. Justice Harrison clearly has an important part to play in this appeal. And the appellant's case is erected on the proposition that that judgment had resulted in the setting aside of the sale to the Piccotts. And therefore, I think we should, my Lord said at the beginning, examine that proposition.
Well, I don't want to take you out of your course, but I would like to know, if I may, at an early stage, what you say the effect would be if the Court of Appeal judgment stood. What would be the effect, for example, on Maisie Hines?
Yes, well, Maisie Hines initially, as your Lordship will recall, bought from the Piccotts and sought to enforce that agreement. In fact, as I will hopefully show your Lordship, she advanced the proposition that the Piccotts had an equitable interest and an agreement which was enforceable, and therefore she was entitled to insist that they should maintain the agreement to her. So that insofar as Maisie Hines is concerned, if the Piccotts have succeeded, then she could look to them for the enforcement of their agreement with her.
But that means that they get the 240,000 and she gets the property. Yeah. But that's not what we're trying to achieve now, either.
No, what I'm saying is that she has an agreement which she had with the Piccotts and which she insisted she was entitled to enforce, and indeed brought in action for its enforcement. At the time when she entered the agreement with Mr. O'Connell, she was aware of the fact that Mr. O'Connell had and I put in quotes, an agreement with the Piccotts, which the Piccotts were seeking to enforce.
Yes, but
in fact, she was maintaining that that agreement was enforceable. And you recall there was a letter written by Hines and Hines which said that he's still entitled to enforce that agreement.
Quite, but if one view would be that when it all comes to be unravelled, if it does, one should end up with that. Your client gets, suppose you win at the trial, your client gets the 240,000 and she gets the property. But that's not the result you're seeking to achieve, is it?
The result we're seeking to achieve is the maintenance of the order for specific performance.
Yes, but never mind about the maintenance for specific performance, but at the end of the day, your client is seeking to do better than giving her the property and keeping the 200 or being paid the 240,000, isn't it? You want to be in a better position.
I'm not sure that he can do that, and I have no instructions on that, but surely.
But that's right, your clients are seeking to do better than that, because the property value has probably gone up since then, and they want to have the value of the property. I mean, that's the long and the short of it, isn't it?
I don't think he could succeed in doing that, my lord, and this, the order for specific performance was not made in that context.
Well, what can you tell me, what are you envisaging is going to happen if you have an order for specific performance in your favour against Mr. O'Connor. What happens to Maisie Hines? She's living there, as I understand it. She's paid out a large sum of money for the property. What are you going to do? Because you've already tried unsuccessfully to get her to pay rent and to vacate the premises.
But if we
Are you going to apply to set aside the judgments that have been given against you on that?
My Lord, Your Lordship will recall that she started paying rent to the respondents.
Well, with respect, that's not quite an answer to my question.
I know, but in order to answer with respect, my Lord, I have to indicate what the relationship was. She was paying rent, and that was the arrangement, it seemed, with all of the purchasers, that they paid rent whilst they were in possession. Now, at the time when the actions were brought for the recovery of rent, no title had yet been transferred to the Piccotts, and so they were not in a position in the resident magistrate's court to prove their entitlement to possession. She, Maisie Hines, stopped paying the rent to Piccott, and that was the source of the disputes in the resident magistrate's court, because she was no longer paying rent to the Piccotts.
Well, yeah, but...
So that if there would not have been a dispute that appears as between the Piccotts and Maisie Hines in respect of those...
We don't have Miss Hines here, but on the face of it, she thought she'd bought the property from you, your clients. Then the proceedings before Mr. Justice Harrison. She then thinks, rightly or wrongly, doesn't really matter in the present context, but surely reasonably, well, the people I thought I bought this property from haven't actually got it, so I'll buy it from the person who I think is the owner of the property, Mr. O'Connor, and she does and pays for it. And what I'm interested in is how will the situation unravel itself, if indeed it will unravel itself at all, if you have an order for specific performance of the property in your favour.
But in the normal course of things, if a purchaser buys and then sells, in order to complete his sale to a third party, he would need specific performance of his agreement. So that there's no inconsistency between is seeking specific performance and is selling to the third party.
Well, what would prevent your clients, if this appeal is dismissed, from bringing yet another set of proceedings, and I've counted, I think, 7 at the moment, against Miss Hines for rent and possession on the grounds that by an order of the court, your clients, are the owners of the property? What would prevent that from happening?
Well, he would have been entitled to the rental during the interim period, but also until the sale is completed, Mr. O'Connor is entitled to rental from him. That was the arrangement, and he would not be able to escape that. Each party was entitled to the arrangements during the interim period until title was transferred.
But surely if you're right, and it's held at a trial, that there was a valid sale of the property to your client in 1984, the just result would be to give your clients the 240,000 plus probably the rent in the meantime, which Miss Hines is being paid to Mr. O'Connor. So you'd get the 240,000 plus the rent, and Miss Hines would keep the property.
And
what's wrong with that? That would be the just result. Otherwise, your client is going to get some great windfall as a result of the increase in value of the property in the meantime.
But for him to do that, for him to transfer to Miss Hines, he would have had to have a transfer to him. For the Piccotts to transfer to Miss Hines in accordance with their agreement, he would have had to be able to have a transfer made to him, and that was the reason for that was the reason for specific performance, he had to get title in order to transfer title. So that the rental, there's one other factor in the rental, in that he was also obliged to pay rental to O'Connor. So that in that interim period, I would add another factor to what your Lordship has said, is that he would also have to pay rental during that period to O'Connor.
I'm sorry, who will have to pay rent to
The
O'Connor?
Piccotts would have to pay rental to O'Connor, because until the purchase price was paid in full, the arrangement was that the purchasers had to pay rental, and that was never discontinued. And that is why there was the constant demand, long after the judgment of Mr. Justice Harrison, for arrears of rent by Mr. O'Connor's lawyer from the Piccotts.
When the matter was before either the Court of Appeal or Mr. Justice Cook, was there any consideration of the independent position of Miss Hines?
No, I don't think there was.
So the Court of Appeal plainly erred in principle there, didn't they? Because they surely couldn't make an order, exercise their discretion to give your client the discretionary remedy of specific performance without considering the interests of the third party. So surely what should now happen is that there should be a trial in which Miss Hines should be present, in which the interests of all parties can be considered. And that's never happened.
The interest of the third party would not, with respect, be defeated by an order for specific performance, because an order for specific performance would have placed the Piccotts in a position where they would become answerable to Ms. Hines. Ms. Hines was taking the position, I think quite correctly, that the Piccotts should insist on their agreement in order to be answerable to her. That was her initial position. So she was quite aware of the fact that the Piccotts was claiming the equitable right as purchasers in possession, and that if they succeeded, that she would then be able to claim against the Piccotts. That was the position she took. And that was put in her application for specific performance against the Piccotts. It was put in her affidavits and in the letters which were written, so that her position initially was consistently in favor of the enforcement of the Piccotts agreement.
With her?
Yes, no. You see, the position taken by the appellants.
But if that had happened, and your clients would have been happy with that, would they?
I would think they would have no alternative.
So if they now end up in that position, assuming they're otherwise right, then they can't complain, can they?
But that is not a reason, my Lord, to set aside the order for specific performance. The order for specific performance was made in a context in which the owner of the property, and there was never any doubt that he was a registered owner of the property, had appointed Mr. Silvera to act on his behalf. I would submit that on this evidence it would have been impossible to sustain a defense which did not accept that Mr. Silvera was engaged to effect sales of these units. So that when eventually the appellant ratified those sales and adopted them and had the purchase price used to pay his debt to the Bank of Nova Scotia, and wrote letters indicating that that sale had taken place and offering to return the deposit, I would submit that clearly there was an agreement which had been ratified and was enforceable. And my learned friend said that we should look at the at the terms of the Harrison order, as well as on the way in which persons responded to it and treated it and understood it. And I think on that examination, Your Lordship will find that that order did not result in a declaration that any sale to any of the 4 purchasers was void. It did not deal with that, nor was the court asked to deal with that.
Mr. Barnett, just looking for a moment, if we could, at the order of Mr. Justice Ellis, that's page 7 of the record. And after the words, "it is hereby adjudged," you then get, "plaintiffs be granted specific performance of the agreement for sale made between the parties." Now, which agreement do you say that is?
That is the agreement which was made in 1983, which had Silvera and Tomlinson as the vendors.
Is that in the record anyway?
Yes, my lord, that's at page 11.
Well, page 11 is the 27th of June 84. And Mr. O'Connor is not a party to that.
Oh, yes, that is conceded, because what had happened is that you recall that when the matter went before Mr. Justice Harrison, Mr. O'Connor had said that Melbourne Silvera had sought to sell and get the benefit of the sales, and had put himself, therefore, as vendor. But those sales were really conducted as agents, and in fact, he was in a fiduciary relationship and was selling O'Connor's property, so that O'Connor was entitled to treat those sales as his sales, and that he was entitled to the purchase price, which is what he did.
So this is a reference to the 27th of June 84 agreement, is
Yes,
it?
my lord.
Which your clients must say was an agreement with Tomlinson and Silvera acting as agents for Mr. O'Connor. Is that right?
That is correct. And this is what, if you look in the affidavit, which was in support of the notice of motion, which your lordships have already looked at pages 8 and 9.
But then wasn't the effect of the order of Mr. Justice Harrison that this agreement of the 27th of June 84 was not binding on Mr. O'Connor?
No, my lord, and that's why I wanted to start there. That decision of Mr. Justice Harrison, if you'll kind of look at it, at page 75.
Well, yeah, the decisions are 43, and I think the originating summons is 75, isn't it?
Yes, my lord, and the decision is at 74. They face each other, so it's easy to compare what was.
Right, okay,
for.
yes, right. 74 and 75.
My lord, if you would kindly allow me to point out first what were the questions which the court was asked to decide.
Yes.
It was asked to decide whether Melbourne Silvera, being the plaintiff's attorney at law, and an employee of the said firm Silvera and Silvera, could in law secretly purchase the plaintiff's property. So that question was directed at the secret purchase, without allowing him to have independent advice. And B, whether Mr. Melbourne Silvera and an employee of that firm could validly sell the plaintiff's premises to third parties and keep the profit therefore to themselves, so that he was therefore asking the court to make a decision in respect to secret profits by a fiduciary.
Well, it goes on to ask for various declarations.
Yes, I'm about to go to those now.
Right.
Because the declarations asked for do not quite fit into those questions. In respect of Declaration A, which was granted,
I mean, he says such purported sale was void.
Right.
That's the declaration, and that's the declaration which was made, or one of them.
So that,
What can that mean, except that there was no binding contract binding on Mr. O'Connor?
what it says, my lord, is declaration is granted, and if you exclude the first finding, which is an employee of the said attorneys at law, and that is where the plaintiff secretly purchased the plaintiff's premises without advising. The plaintiff's attorneys secretly purchased the plaintiff's premises without advising him as to who are the purchasers and to seek the advice of an independent counsel. So that clearly, that declaration relates to the purchase by Silvero of the premises.
Yeah, but the difference between the parties on this point is that you, as you accepted a moment ago, have to say that the agreement of the 27th of June 1984 was one made by Tomlinson and Silvera acting as agents for Mr. O'Connor.
Or in a fact, you say capacity. Yes, my lord.
Whereas Mr. Justice Harrison's judgment appears to be predicated on the basis that that wasn't the case, and that what happened was that the property was purportedly bought by Silvera and Tomlinson, and if that is right, then the agreement on which you rely is one where these two were not acting as agents for somebody else, but were acting on their own behalf on the basis of a contract which later Mr. Justice Harrison has said was void, where they acquired the property themselves. So that's the difference between the parties on this point, isn't it? You have to say that these two, Silvera and Tomlinson, were acting as agents for the defendant in your action for specific performance. But then you've got an inconsistent judgment of Mr. Justice Harrison, which in effect is that they weren't acting as agents, they were acting as principals.
The judgment of Mr. Justice Harrison specifically deals firstly with the sale to Silvero and Tomlinson in Declaration A. In respect of other transactions which the court was aware of at the time, there was no statement in respect of that other than the declaration at E, which is that the defendants render the plaintiff a full and accurate statement of account of all receipts and payments made in respect of any transaction pertaining to the said premises, so that in respect of that declaration, any other transaction other than the sale to themselves would have to be the subject of that order for account.
But if I think I'm going over the same point again, forgive me, but if Mr. Justice Harrison came to the conclusion that there was a purported bargain, and I'm using the word neutrally, between Mr. O'Connor and Messrs. Silvera and Tomlinson, which was void, then when you look at what appears to be the later agreement, which is Tomlinson and Silvera to your clients, it begins to look arguable, to say the least, that the agreement on which you rely was not one made by Tomlinson and Silvera as agents for the defendant, but one made on their own behalf. In which event, if that's right, you've got the wrong defendant as the one for which you're seeking specific performance. I don't say you are right, but it produces this conundrum as to were they acting as agents, which Mr. Justice Harrison, I would have thought, clearly thought they weren't, or were they acting as principals, in which case there is I would have thought, an insuperable defect in trying to get an order for specific performance of an agreement which was never made with Mr. O'Connor.
No, my lord, I did stop there. I would respectfully say that that would be it. But it goes on to the point at which Mr. O'Connor adopted those sales. And although the Silvera had acted in an unauthorized manner and quite improperly, it was open to O'Connor to ratify and to adopt those transactions, which is what in fact he did.
That's the letter of the 4th of September, is that right?
Yes, my lord, and the fact that he admitted that he was aware of sales and that the proceeds of sales had been used to discharge or towards discharging his debt. So that although Silvera and Silvera sought to make a secret profit on their own, he was entitled, as in the case of any other principle against a fiduciary, to claim those profits and to ratify the agreement.
On that basis, Mr. O'Connor, after Mr. Justice Harrison's judgment, adopts the deal which Silvera and Tomlinson made with your clients.
Indeed.
Yes.
And
well, that's not.
3 other persons.
That doesn't look to be the basis on which you applied for an order for specific performance.
If we go back to the...
So this argument though assumes that the purported sale, or the postulated sale to Silvera by Mr. O'Connor was void.
Indeed.
Right. So we're now looking at the case on that hypothesis, that was void, and we're now looking to see whether there was any other basis upon which there came into existence some kind of valid contractual arrangement, and you say ratification.
Yes, indeed.
So we need to look at the statement of claim to see if that's the way it was put.
Yeah. And
so where's the statement of claim?
It's at page 8. I'm sorry, page 3.
Page 3. Yeah.
And in paragraph 2 it says that he acted as a defendant's agent. And in the affidavit in support of the notice of motion, which is at page 8, he says at paragraph 10, the disposition has been recognized and adopted by the Attorney General for Keith O'Connor, shown in his letter dated September 4, 1990, and exhibited and marked PC 6, which is at page 31.
I'm so sorry, Mr. Bonnet. What are you reading
I
from?
was reading paragraph 10, my lord.
Of
Page 9, which is the affidavit in support of the application, which says we propose.
I see, yes.
And that it makes reference to the ratification, which is at page 31, which your lordship has already seen. Now, that letter could not have been written by Mr. Little, who was present at the hearing before Mr. Harrison J., excepting on the basis that he also understood that the appellant was continuing with and ratifying the agreement, because he is asking for Mr. O'Connor to come in to discuss with him the return of the deposit, not on the basis that there is no contract, but on the basis that his client was having difficulty in obtaining a title to transfer to him.
What's meant by paragraph 12?
You're going back to the affidavit, right?
Yeah, in the affidavit, yes, page 9.
That we have requested the defendant and the defendant's attorney at law to complete the agreement, but not very believe that there seems to be a plan to sell to another purchaser.
And who's that? Maisie Hines?
It could very well be Maisie Hines. Could very well.
There seems to be a plan to sell to another purchaser, but your clients must have known by then that Mr. O'Connor had agreed to sell it to Maisie Hines some 5 years earlier.
Yeah. Well, the sell and sale has been used in a loose way in throughout these documents, as your lordship would have observed before. And at this stage, of course, there's no completed agreement. Yes. So that
Mr. Bond, do understand? I'm not suggesting, speaking by myself, I'm not suggesting that your clients are wrong, but that the position is so complicated and diffuse, and I have significant worries about the position of the third party who's not here, Maisie Hines, to suggest that, as my Lord Clerk suggested, that a solution to this very convoluted matter is for there to be proceedings in which all those who have an interest in this property are represented and can put their point of view. You will say, well, the agreement I made with Mr. O'Connor is slightly complicated because I first of all agreed to buy from Tomlinson and Silvera. Then when that fell through in September 1990, in effect, Mr. O'Connor said, well, that's all fallen through now, and I've got a declaration from Mr. Justice Harrison. I'll sell it to you. And you may be right. I'm not saying whether you're right or wrong at the moment. But the argument the other way is no. The specific performance proceedings were misconceived because you've got the wrong defendant. There never was any form of binding agreement for Mr. O'Connor to sell your clients the property in question, and that if an order for specific performance is maintained, this, among other things, produces a chaotic situation as regards the rights and interests, if any, of Maisie Hines.
My response would be, my lord, that the rights of Maisie Hines would not be adversely affected by the order for specific performance because her primary and initial agreement to purchase was from the Piccotts. And when she bought from O'Connor, that was at a time when she was already aware of the Piccotts' interest, so that her equitable interest would be much less secure, relying upon the subsequent sale with knowledge of her prior equitable interest. So that I think her best position is clearly that I had an agreement to purchase from the Piccotts, and the Piccotts are entitled to the property, whereupon I can look to them.
Well, again, can I come back to my first question? What then happens, as far as we can gather from these documents? Miss Hines has paid nearly $250,000 for this property, but hasn't got it.
But she will get it on the transfer to her, but anyone who has collected from her who is unable to transfer title because of either because of the order for specific performance or for any other reason, would be liable to her. And that is an inescapable fact. At this time, she has to look to either O'Connor or the Piccotts. And I would submit, her first position is that she had an agreement with the Piccotts which, as she maintained at one time, was an agreement which the Piccott should enforce because it was enforceable. She resigned from that position and then made a deal with O'Connor on a basis which I submit is unsustainable, because that was not her first position. Her first position is, despite the order of Mr. Justice Harrison, the Piccotts were still entitled to enforce the agreement.
Perhaps there ought to be two orders for specific performance. One, the specific performance of the 1984 agreement, and secondly, a specific performance of the 1988 agreement.
And that is not unusual.
Just adjusted, if you win this, adjusted so that Mr. O'Connor simply pays the Piccotts the rent and the purchase price.
That's not
And then you'd be back to square one, everybody would be happy. But what I'm worried about is what your clients really want to do is get hold of the property for themselves, make sure that Miss Hines sees nothing of it, and then, no doubt, cash in on it if the market has moved along, which it probably, well, I don't know whether it has or hasn't.
They wouldn't be able
But
to...
the solution I suggest would be everybody goes back to the 1980s. Your clients seem to want to go back to the 1980s to enforce the 1984 agreement. Well, what about an enforcement of the 1988 agreement as well, adjusted for what's happened since?
But our enforcement of the 1984 agreement, I'm repeating myself, is dependent on the enforcement of the 1984 agreement.
Right.
So that the enforcement of the 1984
So then, what I'm
agreement...
anticipating is a sort of order, which you have, first of all, the specific performance of the first agreement, then the specific performance of the second agreement, which ends up that Miss Hines keeps the property.
Which is exactly what she was seeking. She was...
And I'm suggesting that now.
She was seeking that the 1984 agreement...
But I'm suggesting that from now, as a just way forward.
To deprive my lord, it doesn't seem to me that giving Mr. O'Connor an opportunity to seek to repudiate an agreement which he had affirmed in circumstances in which he admitted that he had authorized Silvera and Silvera to conduct sales would be a just way of resolving the matter. To give support to Mr. O'Connor, who was guilty of years of delay, would not, in my view, be protecting Miss Hines, would be protecting Mr. O'Connor. And I will remind your lordship that in his affidavit of the 23rd of April 90, which is one of those handed in, there were two handed in, one of the 26th of September 1989. He made it clear that he had given what one might describe as general authority to Silvera to sell. So much so that he said he had signed agreements for which he did not receive any copies or did not know who were the purchasers. And that is in the one of the 26th of September 89, in which in paragraphs 3 to 5 he described his relationship with Mr. Melvin Silvera, and in paragraphs 6 to 8 he described his signing of agreements for sale.
Well, it looks as though it was that agreement that the order of Mr. Justice Harrison related to.
to the agreement.
1983 agreement.
Yes, my lord, which purported to treat Silvera and Tomlinson as purchasers.
And he said that that was void.
Yes, my lord. And the point I make in respect of that is that he did not say that any of the other agreements were void. Although those agreements were then known, there was no request to declare those void. Then in paragraph 8, he said he signed 4 agreements, and sometime in the middle of 85, he was informed that 4 units had been sold. And what he was complaining of is that Mr. Silvera was seeking to make a secret profit out of those sales. And in the affidavit of the 23rd of April 90, in paragraph 3, he states that payment of my indebtedness to the bank was made from rent received from the 4 apartments over the approximately 6 years period, and monies received from the sale of the said apartments to the 4 purchasers. So he has benefited from the deposits which these purchasers had made. Having acknowledged that in his affidavit, my lord, I would submit that Silvera was clearly appointed as his agent to effect sales. He acted in breach of that authority in seeking to sell to himself and of his fiduciary obligations. But it is clear that the appellant, insofar as the sale to the 4 purchasers are concerned, adopted those sales. As you also have to look at page 141.
So on your case, there are 2 agreements, are there? One in 83 between Mr. O'Connor and Silvera, is that right? And then another one, or 4 more agreements, in 1984, which is the one we're concerned with, is the 27th of July 1984. Is that your position?
Yes, my lord. The dates are not too clear, excepting for the...
Yeah, but there are 2 separate agreements.
There are 2 separate agreements. I can go that far.
But the 4...
certainly...
sorry, Mr. Bonnet. The 4 agreements referred to in paragraph 8, they can't include the 27th of June 84 agreement because that has no provision for signature by Mr. O'Connor. He's not even expressed as a party to it. So these must have been some other agreements.
It does. I accept that with respect, my lord, but what I was trying to indicate is not that those were the actual documents, but that was an indication of an authority to sell 4 apartments, that he had signed 4 different documents, agreements for sale, because Silvera and Silvera had been authorized to effect sales of all 4 apartments.
Sorry to go back to possibly square one, but your case for specific performance depends, doesn't it, first of all on a binding contract between O'Connor and Silvera, secondly between some sort of binding contract between Silvera, possibly also Tomlinson, and your clients.
No, my lord, no. My case is based on the adoption of the sale to my client by O'Connor. which he can do as the principal, as the owner of the property. He's entitled, if his agent has entered into an agreement, which would normally be capable of being set aside, to say that I will accept this agreement, ratify it, and proceed with it,
And
which is what I'm saying he did.
And that's the, which document is that? What page is the document on?
31, I think.
31, is it? Okay. Yes, I see.
Because he was never disputing at any time, as I understand it, that Silvera had been appointed an agent to effect sales of all 4 apartments. He was never disputing that Silvera had a fiduciary relationship in relation to him. On page 141.
But the issue of adoption of a contract, of a contract which had been declared void, doesn't, is this right, doesn't appear in the statement of claim, but it is mentioned in an affidavit in support of the application for judgment.
Yes, my lord, I'm not saying that Mr. O'Connor adopted the contract which the Silvera and Tomlinson are described as purchasers. What I'm saying is that he adopted the sale to Mr. Piccott and Mrs. Piccott and the other 3 purchasers. He adopted all those 3 sales, as he was entitled to do. He was entitled to ignore the transaction by which Silvera purported to buy the property, but he was entitled also to adopt the sale to the 4 purchasers. What I'm submitting is that there is a very well-established principle of law which allows a principal or a person who has appointed a person as a fiduciary agent to adopt an unauthorized act or an act which has been done in breach of the fiduciary's duties and to implement that agreement. And if he has implemented it, especially if a long time has transpired after he's aware of the transaction without questioning it, then the court will treat him as being estopped from challenging that agreement. And years passed. I was saying in paragraph 10, he admits that there was a fiduciary relationship. I think it was impossible for him to do otherwise, on page 141. The next passage I would ask the Lordship to look at is at page 154. And this is an affidavit which was filed as late as in 2001. And in paragraph the paragraph which begins, there's both 9 and 10 beside it, on page 154. You said that despite the fact that the plaintiffs have obtained a judgment from the Supreme Court dated the 21st day of May 1998, I have never sold my property, namely 26C, to either the first or second plaintiffs. That sometime in 1984, Messrs. Silvera and Silvera, attorneys at law, purporting to act on my behalf, attempted to sell the said property to the plaintiffs herein, but the said sale was never completed. And then in 1998, I filed suit against Melbourne Silvera, the firm of Silvera and Silvera, attorneys at law in the Supreme Court in respect of the attempt to sell my property. So that in 2001, in supporters of application to set aside the default judgment, makes that statement which indicates his relationship to Silvera in paragraph 25, the defense which he intended to advance is that I've never entered into an agreement for sale with either the first plaintiff and or the second plaintiff, which is technically true. And then B, that I've never authorized Melbourne Silvera to act as my agent in respect of the sale of 26C Silverdine Drive. Now, that is an impossible contention for him to sustain. C, that I've never received any monies from either the first plaintiff or the second plaintiff in respect of the said property, either by way of deposit or purchase price. That again is impossible for him to sustain because he had admitted, as your lordships would have seen in the affidavits, that monies received from the purchasers had been used towards discharging his liability to the bank. And then he speaks of his agreement in 1993, that is several years afterwards, to sell to Maisie Hines. And that Maisie Hines is in possession. But of course, Maisie Hines had initially been put in possession by the Piccotts. And my lord, how was the matter viewed by other persons? It is a proposition that the learned friend invited your lordship to examine. If you look at page 210, this is in the second set of volumes. This is an affidavit in support of the notice of application for the extension of time for filing the appeal. Another example of the delays. You will see at page 210, paragraph 10, that the appellant's attorney says that the delay in the filing of the record of appeal is attributed to the following factors, namely, defendant appellant is presently engaged in litigation in the Supreme Court in respect of apartment 26 Silverdine. Succinctly stated, the doctors, not having paid any rental for several years or having paid the purchase price or any part thereof, have doggedly attempted to obtain the defendant's appellate said premises by legal means. Defendant appellant retained Mr. Garth's letters as attorney at law in this matter. Thus, the defendant appellant did not have the wherewithal to file a record of appeal. Now, that action, it is referred to there. Your lordship will find reference to it at page 253. Where the doctors are now the defendants, and they say the defendants say that they had a valid agreement for sale in respect of which they obtained an order for specific performance in this honorable court on the 22nd of January 1987, and an order for cost against the claimant. Paragraphs 1, 2, and 3 of the particulars of claim are admitted. In respect of paragraph 4 of the particulars of claim, the defendants say that they paid on account of the purchase price and closing costs the following amounts, and they set out the amount. And on page 254 at paragraph 5, they say the subject property is part of a subdivision which was approved by the KCC on the 6th of April 1985. A letter of possession was given to the defendant on 27 March 86, and there was a certificate of numbering of the premises issued against the signature of the town clerk. So that what appears to have happened, my lord, if I might just digress for a moment, the subdivision approval was granted, but in respect of the particular unit which was sold to the Piccotts, there was a structure, not apparently on the main building, which trespassed on the boundaries and had to be removed in order to have the title perfected. And that added to the delay. Now, if your lordship also look at page 108, this again is an affidavit filed by, this is from Ella Gale,
So sorry, what page are you on now?
108, my lord.
108.
The affidavit filed on behalf of Mr. O'Connor, which says that prior to this plaint being filed in the resident magistrate's court, the defendant had in fact entered into an agreement for sale of the said premises with the plaintiff Paul Piccott, and exhibit here to file identification a copy of the said agreement for sale mark PG1. Again, we don't have the exhibit, but that's an admission by O'Connor's attorney. I'm sorry. My friend says that it refers to Heinz's agreement, and that may well be correct. So that I would submit, my lord, that the evidence is virtually irrefutable that Silvero had been appointed to act on behalf of Mr. O'Connor in effecting sales of the housing units he purported to sell to himself and Tomlinson. And then to effect sales of the units to individual purchasers.
But on their own behalf?
On his own behalf, yes. In selling to himself, he was clearly acting improperly and without authority. But his sale to third parties was capable of ratification by his principal, Mr. O'Connor. And was indeed ratified. Further,
Do we have the whole of the statement of claim?
it doesn't appear so, my lord, but I really cannot explain why. because, as you also pointed out, it ended quite abruptly and just had the prayer at the end.
So this whole case, we're back to the ratification. Original agreement void, second agreement void, but capable of ratification.
Yes or no?
And your whole case depends upon the ratification.
Indeed. Or estoppel, because if you are being aware of it,
It's a pity we don't have the statement of claim to see how it was put.
yeah. Well, certainly ratification was mooted, and I would submit that it's capable of, it is not in any way refuted by any evidence. If that is so, my lord, then the next question would relate to, apart from the cases dealing with agencies and ratification, the next question would relate to the exercise by the Court of Appeal of its discretion.
Well, speaking of myself, as I understand it, your position is that there really isn't and wouldn't be any chaotic situation if the order made by Justice Ellis survived, because you can say that from 1990, as evidenced by the letter from the lawyers for the appellant, there was a perfectly good agreement to sell the property to your clients.
Yes, sir.
And not quite as simple as saying, well, it is the agreement of July 1984, but nevertheless you say that can be spelt out of the documents that we've seen, and isn't affected, as I understand the case, isn't affected by the judgment of Mr. Justice Harrison.
Indeed, yeah.
Because you say Mr. O'Connor's agreement to sell the property to your clients came after and indeed as a result of that judgment. Is that right?
No, I don't think I put it quite that way. What I was saying is that the judgment of Mr. Justice Harrison did not have any impact on the validity of the direct impact on the validity of the purchase by my clients, excepting in the sense that you could say that since they sold as vendors and they had not acquired a title from O'Connor, then it would affect the title. But being agents, if they purport to enter into a transaction, which is a transaction which they are authorized to enter into, but they do it improperly, then that transaction belongs to the principal. If it is beneficial to the principal can adopt it.
Yeah, but if he doesn't adopt it?
But I'm submitting that he has adopted it.
I understand that, but if we were to test this at the moment that your clients purported to sell the property to Miss Hines, what would the position have been? On the basis that you accept that the original sale to Silvera was void, and that was what Mr. Justice Harrison may have declared to be void, I don't think you suggest that any sale by Silvera to your client is valid, or you don't now suggest that it's valid, except through the process of ratification. So if we were testing this in 1988, when your clients purported to sell the property to Miss Hines, that would be an invalid sale, would it?
Well, because ratification doesn't
Doesn't
start from the time of ratification.
No, hang on, I'm testing it before we get to the ratification, first of all. At the moment of the conveyance to Miss Hines, or the agreement to sell to Miss Hines, that would be void because it would be based upon, would have been void, but it was regularised, you say, do you, by the ratification?
But in third
on page
parties,
31.
when third parties rely on ratification, my lord, it goes back to the time of the transaction.
But I'm
with
right,
third
aren't
party.
I? The analysis I put is correct on your case.
Insofar as time is concerned, but not in the result, with respect, because the ratification goes back to the time, so that if the third party acted on the basis of that agreement and it is subsequently ratified, the third party would be protected.
Is that so even if the contract doesn't purport to be on behalf of the principal? You
Yes,
make
my
a
lord.
contract on behalf of the principal without authority, and then the principal subsequently ratifies it, then I can see that there's a ratification which goes back. But I wonder if that's necessarily so, if the contract that you purport to enter into is at the moment it's made void.
I would submit that it is, my lord, and in particular...
You may be right, I don't know the answer.
In particular, if the person had authority to sell generally. Clearly, it might be different if there was no authority at all to enter into any transactions of sale. But in this case, my submission has been, and I think the evidence I submit respectfully supports it, that Silvera had a general authority to sell.
Well, I think I see how you put it, Mr. Barney. What do you say about the approach of the Court of Appeal? Because Mr. Dingemans has suggested to us that it was wrong for the Court of Appeal to apply the new rules as opposed to the old code. And his submission, if I understand it correctly, is that if you look at the transitional provisions, the Court of Appeal could and should have applied the old rules rather than the new ones.
The new rules, my lords, came into effect on the 1st of January 2003.
Now, do you say those automatically or expressly applied to the Court of Appeal?
Yes, my lord, I say that because first of all, if we start from the nature of the application which was made to the Court of Appeal, this is at page 200.
Well, if we just take it in stages, Mr. Justice Cook was operating under the old rules, is that right?
That's correct. No?
Must be, because it was in 2001,
Right.
and the new rules don't come into force until January 2003. So the next question is, so you then get a set of proceedings which at first instance were before the new rules, And when they got to the by the time they got to the Court of Appeal, the new rules were in operation. But the first question is, well, did they apply to the hearing in front of the Court of Appeal?
Yes, my submission is they applied for two reasons. First of all, the application to the Court of Appeal, because Mr. Justice Cook had not really exercised a discretion in the matter. The application to the Court of Appeal, as you will see on page 201, was that the Court of Appeal should treat the matter as a rehearing and exercise its own discretion in the matter. Now, bearing that in mind, the provisions of the transitional provisions which my learned friend invited to your Lordship's attention to. And this is in tab 1.
But are you submitting that Mr. Dingmans is wrong in his submission that there is nothing expressing these rules that apply to an appeal to the Court of Appeal?
Yes, no, I think why I've not accepted the way in which it has been treated by my learned friend is that there is an omission from the rules as stated on page 426 to 27, which I don't think his submissions have taken into account. Which could make a difference to how it operates. And that was brought into effect in 2003.
So this is a new document?
Yes, my Lord.
I don't know that we've got it.
I don't think the Lordship has it. Yes.
Thanks.
And
Well, at the moment, I'm afraid to say I'm a little bit lost. If we turn to page 3 of the first tab in the authorities bundle, you've got something which is called, page 2 in fact, application and interpretation of these rules, which looks similar to, although not quite the same, as the document you've just handed in.
yes, my Lord.
But I do notice on the document you've just handed in, if you look at the bottom of the first page, it has in brackets 18/9/2006.
Yeah. If you look at the
So
side note,
that is an amendment made after the hearing in the Court of Appeal, isn't it?
no, my Lord, the side note indicates when those particular words were put in, which is in file, which is 17th of February 2003.
Well, which rules do you say applied at the date of the hearing of the Court of Appeal? The ones you've just handed in?
Yes, my lord, I'm saying that the rules were altered on the 17th of February 2003.
So what were the ones we had in the bundle?
That was made and came into effect at the beginning of 2003. And then it was discovered that there was this hiatus in the transitional provisions. And so that in February, those words were added.
Sorry, which words?
Which words?
The words, if you see that in this one, my lord, there is a subparagraph which says proceedings save for those in which a trial date has been fixed for the hearing term 2003, and save for applications that have already been filed and fixed for hearing during the hearing term 2003. So those were the exceptions brought in by that amendment.
I'm sorry to be so slow, but I haven't quite grasped that.
No, I'm the same.
So am I.
What we're looking at is what are the exceptions to the application of the new rules for a matter which is heard after the new rules have come into effect.
Yes, forgive me, but we now have in front of us two documents, each of which is headed Application and Interpretation of these rules. They look very similar, but what is the position, if I ask my question again, what rules were in force when the Court of Appeal in this case heard the case and gave its judgment? Are they the ones in the bundle, or are they the ones you've just handed in?
I was submitting that it's the ones which I've just handed, but
Also, the ones that I've got, we've only got two, a bit from paragraphs 2.1 to 2.4. But then,
Yeah,
have we got?
that's all.
Yes, I've got. I mean,
2 pages, isn't it?
the only difference appears to be that in 2.2 little 3, the words family proceedings have been, well, possibly excised.
my lord, there is a provision in the amendment which says that the new rules apply save for matters which were fixed in the Hillary term of 2003.
Yes, it's sub paragraph 4,
Right,
I think,
yeah.
is an addition, isn't it? 224 doesn't appear in the
Oh, I see.
version in the bundle. But it looks as though that was the 17th of February 2003.
Yes, my lord. So that when the matter was heard in the Court of Appeal in 2005, the amendment made in February of 2003, which was shortly after the rules came into effect, as I say, the hiatus in the rules in relation to transition was discovered, and that addition was made in February, now applied. In any event, my lord, it is my submission that it doesn't seem to make much difference in the end, because the Court of Appeal did accept that the overriding objectives should be applied, which it seems would bring the matter back to the original position in any event. And that
Well, I
was
follow, but Mr. Dingerman's point on that, if I understood him correctly, is that the Court of Appeal proceeded on the basis that they were bound by the new rules, although I accept, as they say, they still exercise a discretion. But he says as a result of that, they did two things. One, they placed undue weight on the 3 criteria that are set out in the new rules, and 2, failed to take into account a further factor, which is, as he, I think, put it, the chaotic state that would be created if the default judgment was upheld.
Yes, I've already tried to deal with the second proposition.
If I understand you correctly, you would say that the Court of Appeal was right in exercising a discretion. Would you say they were right or wrong in taking into account the tangled web of this affair over the past 20-odd years? I mean, they don't seem to have, on the face of it, done very much more than say, well, the appellant has only got himself to blame. He had plenty of opportunity and time to put in a defence, to apply to set aside the judgment, all sorts of things, but he deliberately didn't do it. And they seem to have closed their eyes to the point that could be made, which is, yes, all that is true, but the net result at the end of the day, if this default judgment stands, is not only chaotic, but also is calculated to prejudice the position of somebody who is not a party, namely Maisie Hines. Are you saying they were right to ignore that factor?
Lord, the question of Maisie Hines, I have sought to deal with on the basis that the order for specific performance would not jeopardize her position. And secondly, in relation to the factors to be taken into account, as your Lordship earlier said, these are the same factors which should be taken into account under the old rules or not, or under the new rules. And to make an assessment based on what my learned friend has described as giving excessive weight to those factors is not a matter that could be said in this case to be justified. In fact, the delays in this case are so horrendous that it would be contrary to all principles for the court to have ignored the extent of those delays. The delays do not run into days, as in some of the cases which have been cited, or weeks. The delays run into years.
Well, they say that there's a bit of the pot calling the kettle black about that. I mean, you're trying to get an order for specific performance of an agreement which was made in 1984.
But the explanation for that is clear. There was a problem in relation to the completion of the subdivision and then getting the title, which has always been treated as a sufficient reason for waiting for the application for specific performance to be made. And secondly, if you are in possession, the courts of equity have always said that the person in possession as a purchaser is not under the same time limits. It wasn't a case in which there was a fault on the part of the purchaser. The obligation to provide title is the obligation of the vendor. And the purchaser should not be prejudiced by the fact that there were some technical problems in relation to achieving the title. Bringing an action for specific performance until the legal impediments for the title had been removed would have produced no result. So that I would respectfully submit that the delay to bring the action for specific performance is not a culpable delay on the part of the Piccotts. On the other hand, the failure to file a defense, the failure to apply to set aside the default judgment, the failure to proceed expeditiously with the appeal, I mean, these are matters which went not barely for months, but for years.
Did your clients resist Miss Hines' application to be a party to these proceedings?
Seems so, my lord. I don't think I was present, but it seems that it was resisted because, well, the fact that it was not granted does suggest that there was an objection to it.
Well, if I correctly understood you, Mr. Barnett, you say that it doesn't really matter that whether the court was strictly correct in applying section 13.3 of the CPR, because, as you correctly point out, they nevertheless exercise a general discretion given to them under Rule 1.2 of giving effect to the overriding objective, which is to deal with cases justly. And you, as I understand your submission, say, well, having done that, even though you might have said it was arguable that they didn't have to apply that, there is nothing wrong in the judgment of the Court of Appeal, and that we shouldn't interfere with it.
Yes, my Lord. I say they took into account all the circumstances as they state in paragraph 32, which is what under any provision of the rules, old or new, they were obliged to do. And in doing that, they held that there was no basis for the grant of any further indulgence to the appellant. They had examined the factual basis, the affidavits which he had filed in 89 and 90, and they were seized of the facts. And I would submit they have not taken a wrong approach or acted on the wrong principles of law.
Well, I think unless there's anything you wish to add, I think we have those points. Was there anything else you wanted to add?
No, I have not had a chance to refer to the cases, but those cases establish general principles in relation to two matters which we have been discussing. One is the practice or the legal principles on which the court, in exercising its discretion, will take into account factors such as delay, but tests in relation to whether you have an arguable defense, or in this case, it's a higher standard, as some of the cases have indicated in recent times. And in assessing the question of whether you have a sufficiently strong defense, then whether you have made conflicting statements with that defense is a very critical issue, and I've pointed out those conflicting statements by the appellant in relation to the agreement. And as I say, eventually it has not been shown that the Court of Appeal exercised its discretion wrongly.
Well, thank you very much. We'll rise from there and see where we're getting to.